Hello, I'm Jerry Wong, and I'm a judge of the Ontario Court of Justice in Canada. I sit in a small town called Chatham, where I do a combination of family, which includes child protection, as well as what we call civil family, custody and access. And I also sit criminal, so I'm known as what is a two-hatter, doing both criminal and family. As part of the criminal, I do youth work. And my background prior to being appointed to the court was as a children's advocate through the Office of the Children's Lawyer in Ontario. I also did, as a lawyer, an advocate, family law, both child protection and civil, and I also was an accredited mediator. Matt Sullivan, take it over.
Hi, I'm Matt Sullivan. I'm a clinical psychologist, and I have worked in the family courts predominantly for about 30 years. I practice in California, and in the courts I do a combination of mostly co-parenting work and parenting coordination. I founded a nonprofit called Overcoming Barriers, and for the last probably 10 years have worked with that organization and some really amazing colleagues on these cases that we're going to talk about today. Very high conflict situations where there are parent-child contact problems, which we will explain to you what they are and sort of the state of the field in addressing them. So Jerry's gonna lead off, and we're gonna do kind of a back and forth with each of us taking the lead in particular slides and doing some dialogue back and forth.
And in preparing for this, we talked about what it would look like to you, the listeners, the judicial officers, and we thought it was best to have the information sharing in an informal way. So rather than Dr. Sullivan and Justice Wong, we went with the preferred way of Matt and Jerry, and want to present it in a more conversational discussion format than the formalities that you might see with a judicial presentation with justice and doctor. And so the first slide talks about fix it. And this is what we've talked about, I think, many times in terms of what's in the toolbox, in this case, what's in the tool belt. And it's really what's in the back of our minds as we approach these kinds of problems. And if there's a theme coming from my point of view, it is that there would be a bubble in the back of my mind as I'm thinking about these files, and it's called hope. That I am always hopeful that something I can do, something I can say, something I can create with the help of the professionals is going to help this family, these children. So with that in mind, I pick up a file and I start to read it, and I'm reviewing it. In our system, we have case management. So the file I'm looking at could be a case conference brief. It could be, however, the pleadings, an affidavit in support of a motion. But I'm reading court documents prepared generally by lawyers. We have a high number of self-represented people, and so many times paperwork is presented to me that's truly written by the litigant, the parent themselves. As I'm reading it, I'm questioning in my own mind what's going on, what has happened. I could be looking at it at various points in time. It could be the first time the case is in the court system. Perhaps the problem is already crystallized. It could be a motion to change, where someone has come back to court to try to change because for sure the problem has crystallized and there might be some resistance or some contact problems that are very clearly there. So I'm questioning it not just from a litigation point of view, but questioning it also in terms of the family dynamics. What has happened here? What has changed maybe since the last court order, or if there was an agreement? And I'm also starting to think about my feelings, something that I'm critical of lawyers who come to court and talk about their feelings or their clients' feelings, but I think it's important to put it on the table that always, as judges, we think in terms of right and wrong. We think about an injustice, and we have to be very careful here. We might not have anywhere close to the right amount of information or even the right information to start determining what is wrong. And so if there was another bubble in my mind, it's a precautionary to remember not to judge, to be really looking at this as a questioning or investigation part of what we need to do. And that's really then the last part of the slide, thinking, what do I do next? Over to you, Matt.
So what is
So
this
this,
problem? Um, the presenting problem typically, when it comes into our office, if we are professionals who work in the family court system or the court as the judge, is that there is a child resisting or refusing contact with one parent. Typically, this is the non-custodial parent, and that by definition, and this is a change in the last 30 years, the rejected parent is seeking some kind of way to address that. It may be resistance at this point. It may be outright rejection that's led to no contact. That's the presenting problem. What we know is that 25% of cases when parents are separating and divorcing remain high conflict 2 to 3 years post-divorce, so about a quarter. 12% are cases where a child is resisting contact, and that number rises to up to 20% in cases where there are disputes that are in the court process. So this is just a graphic that talks about children's responses in high conflict divorce and separation, where, as you can see in this pyramid, as you reach the bottom, you're going to have some parent-child contact problems that manifest. The very top of the chart, there's a strong attachment that children have to both parents, and regardless of the conflict that the parents may be having, it remains strong, and they kind of weather that war, if you will, and maintain a meaningful relationship with both parents. As you move down the pyramid, there are kids who will develop affinities to one parent. That's a preference to a parent, might be based on gender, might be based on shared activities, but if you ask them about preferences, which is often what the voice of the child is asking, they'll say, yeah, I like mom better than dad, and these are the reasons. But they won't say, and because of that, I never want to see dad again. So that's what affinities are, and we see them manifest. And then there are alignments, which are kind of, again, beginning to be more problematic, where there's not only that preference, but there's also some more negative expressions of time spent or attitudes towards the other parent. In these cases, it's going to move into more problematic situation when the favored parent, the one who the child is aligned with, is kind of not supportive of the relationship with the other parent, despite the child's potentially protests. The green section at the base of the pyramid are the cases that we're going to talk about today. These are the cases where there is either justified rejection due to things like intimate partner violence or parenting on the part of the rejected parent that is problematic, potentially even abusive. And on the other side of that side of the pyramid is what we call alienation. Which is where there was a previously good enough relationship with a parent, and without alienating behaviors of the favored parent, the child would not be rejecting the other parent. But there's this sort of disproportionate rejection of that parent. Again, alienation defined: a child shares preferred parents' negative behaviors and attitudes and expresses unreasonable aversion to the parent with whom they previously had a good enough relationship. The disproportionality the unreasonableness of that reaction is what we're seeing in these cases. You know, I don't like the way that mom does homework with me. I prefer the way dad does, so I never want to see her again. It's that kind of what what's going on here? There's this sort of disproportionate reaction in that. Looking at the preferred parent and their contribution to this kind of problem on a continuum, the preferred parent may just passively endorse this unreasonable aversion through the support of the child's feelings. That's what we sometimes call that the independent thinker phenomenon, that parent will say, I'm just supporting Mary. You know, what Mary wants is what I support, even though it may be quite distorted and immature. Coming down the continuum, the preferred parent may endorse the child's feelings and actively express their own anger, fear, and opinions. In high conflict co-parenting situations, as you know, parents often have extremely negatively polarized views of each other. And in these cases, they don't keep them to themselves. They actively express these to the child. You know your father was blah, 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 an active alcoholic, abusive. And of course, that's going to influence the child's attitudes as well. And then in the real extreme cases, you're talking about a parent who really is engaged in a campaign of denigration and hate toward the other parent that is meant in a very conscious way to damage and destroy that relationship. We see some of these cases, they're rare, but they are in the courts where that kind of destructive intent is what's happening. So that's alienation. This is an interesting diagram from the Canadian courts, a pretty widespread survey of just court cases where alienation was claimed in 2010. And what's really, really interesting about this, and what I'll say is this is happening everywhere. This is happening in the US. I speak and train in Asia and Europe, everywhere where shared custody is a presumption. This phenomenon, sort of as you can see, had a fairly low incidence rate, fairly stable incidence rate until about 2007, and then it has just spiked. And I would venture to say that that spike continues at least at that prevalence. Why? What's going on here? Why is alienation, as a allegation at the very least, if not ultimately a finding, happening more in the courts? One, I think, is because of the shared custody presumption, which we all believe and the social science literature supports is a good thing for kids. But one of the unintended consequences is that in some situations, the parent, more often than not the mother, particularly with young kids, does not support that presumption. And they don't necessarily anymore have the control that they used to have back in the day when they had the tender years presumption. And basically, you know, the father, if they wanted to have shared custody, had nowhere to go. Fathers now do. You know, there's a father's rights movement that occurred in the late 90s that supported the value of fathers in their child's lives, both, you know, in nuclear family situations and post-separation divorce. And fathers' rights have influenced the courts, and fathers have more standing. So these situations where there's conflict around custody come into the courts. Another movement is the voice of the child, that the voice of the child is considered to be a good thing, but in these cases, sometimes it's not. These kids may not be independent, may not be speaking from a place that is inconsistent with their own best interests. They may be aligned with a particular parent, and then when their voice has more and more authority and legitimacy in the courts, that can be problematic. And finally, I think the internet has had a huge impact on alienation in the courts. As we know in other spheres, the internet and the accessibility of information so easily leads people, parents often, to go to the internet to look up something like, why is my child rejecting me? And they're gonna find information that will validate their perspectives, that they've been alienated or that their partner is domestically violent. But I think that's the reason for this spike from a sort of socio-cultural standpoint.
Just before we move on, Matt, I just want to clarify that although this is a Canadian study done by Nick Balla, we don't have a presumption of joint custody or shared custody in Canada. We are moving towards that, it appears, but one of the other aspects that I think is behind alienation is child support. Child support is tied in Canada to what's known as the 60-40 rule. And if a dad, most often gender-based, but if a dad can convince a judge that he has at least 40% of the time with the child, then there can be a reduction in child support. And so that is a factor that also fuels these kinds of cases. And I think going back to what you say about the internet is exactly the problem. I've had litigants in front of me who tell me the law in Canada is joint shared custody and she won't give it and she's the problem. And a lot of times there's these underpinnings of financial considerations and real life dollars.
Right. Yeah, I can't tell you how many people have called me or contacted me through my website and said, I have the worst case of parental alienation syndrome that has ever been on the face of the earth. Um, hmm, that leads to a healthy skepticism, but you know where they got that they were
Yep.
trolling the internet and
Yep.
and receiving validation for what may be true, but actually, many cases that are presented that way are not severe alienation as they are presented by a particular parent. Um, the other part, obviously, which gets to the this slide, which is this is often what we're faced with. Is it estrangement? Is this the child's realistic experience of the parent that is leading them to reject them, or is it alienation? Estrangement, critically important. The differentiation of these two sides of the continuum of parent-child contact problems is very important for judges to get it right. And they're often faced with one party saying it's estrangement. This is the result of the other parent's domestic violence towards me and the child's reaction to that, understandably, or abusiveness, physical, emotional, sexual abuse. So in those situations, the favorite parent, is appropriately gatekeeping. They are trying to restrict the access of the other parent for good reason, and that becomes the big fight, if you will, that comes into legal adversarial proceedings. Is this appropriate gatekeeping, or is this active alienation? And it's created sort of two camps that have advocacy groups behind them in the larger sociocultural milieu. Domestic violence advocates often feel that any kind of promotion of the notion of alienation is simply more perpetration to women victims of domestic violence. And similarly, the alienation camps will say that it is a valid phenomenon, absolutely, and we are fighting for parents who get erased by malicious other parents. All of that stuff is valid. In the courts, what plays out in the wars is sometimes each parent will use this strategically and tactically when it isn't valid, and of course that's really problematic for judges when they're trying to sort out what
Mhm.
is actually going on. Um, In a lot of cases, what's very important is that it isn't either or, but it's both and. In most cases, both parents have been engaging in some kind of behavior vis-a-vis each other and the child that are responsible for the breakdown and in the relationship of the child with one parent. That's what's critically important and makes it even more difficult. It's not either or. And most importantly, even if it is more significantly one parent than the other, in all cases, both parents must contribute to the resolution of the problem. This is just shown to you to demonstrate, as I put up all of these different factors, which is going to take me like a minute to do, it's crazy, that this is a highly complex issue. And that makes it incredibly challenging for the court to deal with, because the courts generally in these cases are not simply trying to find out who's to blame, which parent is to blame. Each parent, as it's shown in this, the aligned parent and the rejected parent have a contribution, and their conflict, which may stem from during the time they were intimate partners and then been exacerbated by their separation, potentially even more exacerbated by litigation. Their co-parenting relationship is also a factor that influences the child's response. What kid wants to live in a war zone, in the middle of a war zone? And if they don't want to live in the middle of a war zone, they're going to have to go to one camp or the other. And if they go to one camp, then they're going to have to totally reject the other camp. And oftentimes these kids are simply responding understandably and appropriately to the conflict rather than really their experience in either parent's household. And then, as we'll talk about when we talk about interventions, the professional system and the courts can be a helpful kind of intervention, or they can actually make matters worse. So what's going on around the family, with extended family, with professionals, attorneys, mental health professionals, courts, are also factors that influence the child's response. The important thing is that since it's so complex, it's very important to look at all of these factors as you're thinking about, as Jerry was saying, what do we do next? So I'm going to turn it over to her to begin to talk about how to address these issues.
And so this graphic is chosen because I think it can illustrate sometimes what we're trying to do. Again, timing dependent on when the matter is before you as a judge. It could already be blown out of control, but as Matt is saying, it could still get worse. And so it is about trying to sometimes put the Band-Aid on it, hold back the flow of the gushing water, and take a look at what we can do. So the next slide starts to enter into that discussion. Why are these cases so important? And so when we look at a little bit at statistics, yes, they're low frequency, but as Matt has pointed out with that slide, clearly on the rise and clearly something we need to deal with. They also, even though they might be few by comparison to the number of cases each year, they are a large percentage of the time that we devote. The high conflict cases require management. Some courts, some jurisdictions can triage. Some are more effective with a case management system. Whatever you're able to do, I challenge you to say these cases always seem to find a way to be up and back before us on a regular and frequent basis. And we know that this is not a good outcome for the children. We know, as Matt has just said, that kids are often in the battleground and have to choose a side to survive. And so we know that there's problems emotionally and psychologically for the children who are caught up in these kinds of litigation files, that their parents want to be in front of the judge for a finding. I think often it's about they're looking for validation. Parent A wants the judge to say, yeah, you've been wronged. You've absolutely been wronged. And parent B wants to be vindicated, and back and forth. It's also as children get older, a combination too of social media and the internet. Children have access to it. I can't tell you how many times parents ask me as a lawyer for their children and now as a judge, but my child is 13. Doesn't she get to decide what's going to happen? And this morning, before we started this webinar taping, I had a case where the mom said, I don't think my 12-year-old should have to choose between playing with his friends and having time with dad. Time with dad is boring. And I talked and tried to reframe it about when your 12-year-old says, I don't want to go to grandparents' dinner on Sunday, but grandma is turning 90, I want to hang out with my friends. What's your answer to that? And so it gets difficult as children get older because they can vote with their feet, right? What we can say to 7-year-olds, 8-year-olds, 9-year-olds, we can't effectively say to 15, 16, 17-year-olds. And I think we all know we've tried to fix the problem with traditional interventions. That's litigation, it's therapy. I was a lawyer for 28 years before I became a judge and entering my 5th year. And I know those traditional interventions can sometimes work for some of the problems some of the time, but generally the kinds of conflicts we're talking about, they don't work. We have to be creative, we have to think outside the box, and we have to find a way to create a solution that works for each family. So back to the toolbox analogy. What works for family A might not work for family B, or it could be a question of timing. You have to always be looking at the people who are in front of you. So that turns us to the next slide of the professional roles. Attorneys, lawyers is what we call them in Canada. They are clearly the advocate for the parents, and sometimes that's part of the problem. They get retained by parent A who wants, who feels, who thinks, who believes, and some lawyers take that on with blinders and don't think about the children and don't think about the best interests of the child. Their role is for the advocate of that parent, and that's what their retainer says, and that's what they're going to do. Attorneys and lawyers are very important because they really are the gatekeepers to the system. Almost always, even though we have the internet, people contact lawyers, and the lawyers are often the first responders to what the problem is. And in that context, they set the tone. Is it going to be adversarial? Are we going to litigate with ex parte, no notice motions? Are we going to try to get restraining orders? Or are we going to be more collaborative? Are we going to try to be conciliatory and look at it as a bigger problem with underlying issues? Lawyers, as part of their gatekeeping function, can triage to the appropriate process. That is it a negotiation? Is it a combination of family counseling and negotiations? Is it a collaborative practice? Or is this a case that needs to be in front of a judge? And so those are the kinds of things that lawyers are expected to know and assess. So buy-in is huge in terms of having lawyers and attorneys understand the systems and the options. Matt?
Yeah, similarly, mental health professionals touch these cases very early on, and we're going to talk about how important early intervention is. They often touch these cases well before they show up at attorneys' offices because people are thinking about separation and divorce, and certainly the courts. And the issues that face mental health professionals working with these particular cases are that there is not yet developed, and that's part of what overcoming barriers in our organization, nonprofit organization, is trying to do, to bring up the level of knowledge and competence in mental health professionals, because not only if they are not specialized in these particular dynamics that we'll talk about, they will not be effective. But even worse, they often do more harm than good. And most experienced judicial officers have seen mental health professionals who are doing harm in their courts, potentially making child custody recommendations, which is, of course, unethical for a child therapist or certainly a parent's therapist to do. Or you've gotten a letter from a parent's therapist who's diagnosed the other parent as narcissistic personality disorder or antisocial. We need to elevate the knowledge and skill of mental health professionals because, yes, not only is ineffectiveness problematic because time is the enemy in these cases, and ineffective treatment delays, at the very least, it delays effective treatment, and it often leads to a situation where resources are no longer available because you paid for those mental health resources. And also, families get sort of alienated from interventions over time. When families have been in the court system and or in mental health treatment for months or years, they're kind of over it. So it's really important that mental health professionals in your jurisdictions develop the specialization to work in these cases. And there's a lot of good social science literature out that's really focused on this problem in the last 10 years. And that the court system knows who those people are who are really good at working in these particular issues. Jerry?
Yes, that's probably an appropriate place for a plug for AFCC. I mean, AFCC is a great place to get some of this very basic information. Be a member, participate in the conferences. I had great training when I was a children's lawyer, but I also had great training once I found AFCC and came to understand the contributions to my knowledge base that come from hanging out with professionals, talking to people, and participating in discussions and conferences. So really important to remember that. The next slide after the judge is judges in courts. And I think it is really important for us to understand who we are in these high conflict type situations. We do have a critical role in educating parents, persuading parents and lawyers to focus on the needs of children and to avoid harm from conflict. And to that extent, I think we're often the gatekeepers. We're there, we're in the midst of it, and we have authority. And we have authority by function in terms of we're the judge, but we have authority, I'm going to suggest to you as we work through the remaining slides, that it's also about the authority we have as decision makers and in holding people accountable. And so in our jurisdiction, we have a number of programs, initiatives that help people to come to understand the family court system. The mandatory information programs require, as the word mandatory suggests, participation. They have to have a certificate, they have to attend. And so we can build on that knowledge that they have, no matter what your jurisdiction has in terms of access to resources and information, but we should be thinking of ourselves as building on that knowledge base and helping people to appreciate the role of a judge. Might be very focused, might be very specific, might be more conciliatory, might be part of what some people might say is more mediator-like, asking those open-ended questions, trying to get to the bottom of what is really going on. And judges are in a position to identify and influence. Maybe influence should be in quotation marks. I think in many jurisdictions we can direct, we can order people to consider out-of-court services. Again, different jurisdictions are going to have different issues, but in Ontario we can order parties to participate in intake for mediation. Not to participate in mediation, but we can get them in the door. And sometimes that's enough. And so we have those tools in our toolbox or our tool belt that range from mediation to assessments, therapeutic interventions, the list goes on. And I think every year people come up with different ideas as to how to help family move forward. Matt, anything you want to add before we turn to the next slide?
Um,
No?
no, I think you can move ahead.
Excuse me. So the next slide is conventional wisdom doesn't work. And again, if you've been around a while, Matt said he's been doing this for 30 years. I was a lawyer for 28. We're kind of the same vintage, although I think I'm a bit older than him. And so we do know what it means, conventional wisdom, the old ideas. I don't want to say they're myths, but we should be looking at them very critically. And the first one was, if a judge makes a decision, send them out, the dust will settle, the family will work it out. Once it's no longer all about lawyers' appointments and coming to court, people can settle in and devote their energies and their time to figuring it out. And what we now know is, no, that doesn't work. It might work for some people, and that's a good thing, but the research does not bear this out. The research is really telling us that we need to be doing a lot of micromanaging in these files. And so we are the judges in this case. And this means bringing the families back, the parents back on a regular basis, and we monitor the progress. That's what I mean by case management. Again, different jurisdictions are going to have different levels, commitment to what case management is. But the idea in our courts is you're not getting three different judges on three different occasions trying to move your file forward from a litigation point of view and also outside the courtroom. You're getting a dedicated judge, somebody who's going to become a specialist in terms of your family, your issues to move the file forward. And so what we also know is the next conventional wisdom part. Children do better when both parents are involved. That's for sure something that comes off the internet. That's part of the presumption that we sometimes are faced with, whether it's a real presumption of shared custody or just what people want to believe or what they've read and they think that it applies, even though the article they read was from a different jurisdiction. And so what we know as well is that these generalized statements are not accurate in every case, right? We know that there are families and files where one parent has been abusive, and therefore it's very important to remember that, assess that risk and harm, and remember to be safe and protective of the children. Next slide. The next statement of wisdom is give the child some space and she'll eventually come around. And so there's a number of bullet points here, right? It undervalues the importance of the family relationship. It teaches the child avoidant behavior is acceptable. It keeps the child from trusting experience instead of a false belief system. I had a case earlier today, and so I add an additional thing. It gives the child permission when the favored parent says, well, you don't have to go see dad. It gives the child permission to take a stand. And that child, when he or she becomes a teenager, is going to turn to the favored parent and say, now I'm going to tell you what to do. And it's really tough when you've encouraged your child or allowed your child or permitted your child to have avoidant behavior or to do something when the child says, well, how come it was good when we were talking about dad and now when I want to do this? So you can be setting up a whole new parenting issue when parents allow their children to make these kinds of choices. Another, I think this is for sure a myth. Contempt doesn't work in custody cases. Contempt for judges should be rarely used. I think we can all agree to that. Contempt is about money fines. Contempt is about penalties. Contempt is about sending somebody potentially to jail. But it's really important to remember, again, we have authority and we have that ability. And in the rare circumstances where contempt might be the answer, we should not hesitate from using it if we've properly assessed it. It can be a very important tool. And it can be contempt over something very minor, so perhaps the penalty isn't jail or a fine, but rather a redirection. And sometimes drawing the line in the sand on that issue is enough of a message to the parents that they really need to stop this, that the judge is not kidding, that there are, in fact, consequences to bad behavior or what is going on.
Right, and
The next, sorry,
I
go
would
ahead.
just add, Jerry, that that's one of the reasons why that case management, that that micromanagement is so important, because what we know from behavioral theory and parenting is that when you're trying to shape behavior, and by and large these parents have difficulty with compliance often. You want to catch bad behavior early, as soon as possible. Think about working with your kid.
Yeah.
When they misbehave, you can't wait for 3 months and 15 or 20,000 misbehaviors to then consecrate it.
Yeah.
So when you have a situation like, okay, I am expecting, a judge says, in the next week for you to reach out to these particular therapists and set up an intake and get this therapy going. You can't wait for 3 months to see whether they've complied or not. And then if they haven't, to levy some kind of consequence. It's really important to sort of be on it, because, as Jerry was saying, then you can set the limit. You can have a consequence. If you don't get this done in the next week, this will be the consequence. And then, of course, it's important to follow through on that. But all of contempt will be a very rough kind of blunt instrument, which will not be as effective if you don't have an ability to do that micromanagement of the case when people are not behaving as you expect them to in the judicial role.
And I think another point here is, because I'm sure people listening are saying, oh my God, my day is already packed. When will I see these people? He is saying a very short adjournment. This is what I say. Our court days start either at 9:30 or 10, depending on what the day is about. This is where I say to the lawyers, when are you available? 9:15, I'll let you call in. We'll do a telephone conference. I'll let you file something that brings me up to date. So you can be creative, I think, about how you make them check in with you. And what I've learned, sadly, through experience, is to have a plan B, so that I say, okay, we all agree this is what's going to happen in the next 4 weeks. Here's the date, here's the time, here's what's going to happen. And if it hasn't happened, let's start thinking now about what's going to be the next step. So is this a contempt motion? Is this? What are we going to be doing? I try always to have people be thinking 2-3 steps ahead, so that they understand, one, that I'm not giving up, that I'm really going to manage this. I'm going to remember these conversations. I'm going to remember these discussions, which really means I'm not going to accept from the lawyer who's there, oh, Your Honor, we didn't have a chance to look into that. What does that mean? We talked about this. So I really like what Matt says about, it's a parenting issue. It's reminding your children this is what's going to happen. It's the consequences. But it's also preparing them for what's going to happen afterwards, not just in a penalty consequence type setting, but this is how we're going to move it forward. And I think for children, that's very important, that they need to know what's happening next. And for many parents, it's very important. Which brings us to the next discussion about judicial continuity. And this is huge in terms of these kinds of files, that we hear this from feedback from litigants in the court system. There is nothing more frustrating, perhaps exasperating, even exhausting to people, to have to repeat the same thing time and time again. And so their same story. You get 16 court appearances and you have 10 different judges touching the file. There's no continuity, there's no knowledge, there's no trust, there's no relationship building. So we need to end that. You need to identify these cases, whatever your jurisdiction is able to do, and find a way to have these people back and manage it and micromanage it. I talk about focused adjournments here. That's what Matt has already talked about. Okay, in the next 3 weeks, this is what's going to happen. I get lawyers and clients to pick the timeline by which they're going to complete something. If it's unreasonable, I tell them that. But generally speaking, people will say, okay, I need 2 weeks. I'm going to be on vacation. This is going to happen, whatever it is. And because for me, part of that accountability is, You picked these dates. You agreed to these dates when we talked on April 2nd, and now you're telling me, well, these dates were never going to work. So it is about that accountability and holding people responsible. And again, judges have that ability. It's called our authority. We're in charge of our own courtroom. We have judicial independence, and we can, in fact, encourage people, direct people, influence people, order people to do certain things. I think it's really important to remind ourselves that we need to allow the litigants, if possible, to be part of the process, not to let them hide behind the lawyers and the briefs and the affidavits that are clearly prepared by lawyers. Lately, I don't know if this is a spike that's related to the full moon that might be coming, but I've had many litigants put their hand up and say, Your Honor, I want to speak. And this is in the presence of their own lawyers. Their lawyers are talking, answering a question I put to them, and the litigants are wanting to speak. If I was a lawyer and that happened, I'd want to take a very serious look at what my relationship was with the client, in the sense of, obviously that client feels that I am not hearing, listening, advocating to the best way possible. So I think that when you start to see litigants wanting to speak directly to you, it can be a good thing, but it also can be a sign that there's a breakdown in the communication between the lawyer and the client. And you need to separate that out from what the problems are with this family. And sometimes that can get confusing. And again, it comes back to case management. I might not know that, recognize it, understand how to distinguish it, if I didn't already know this family and their dynamics and what was really going on. I think the last thing that I want to emphasize is judges have to dig deep in their toolbox to come up with suggestions, to come up with ideas. And really, this is where I use my mediator skills. You know, have you thought about this? Have you considered this? What do you think about this? What options do you think? If it's a situation where the children are reporting that dad's time with the children is boring, then I get the mother to talk to me. Well, what do your kids like to do? Give us some ideas. What restaurants do they want to do? So that there's some buy-in. People like to be heard. People like to speak. I'm using mom as a source of information to do this. And many times by this kind of conversation, you can carve off, you know, the low-hanging fruit. What is this really about? Is this about dad just doesn't have parenting experience? Dad just doesn't know what his own kids want or are interested in because he hasn't been around. Sometimes it's about financial issues, as I referenced a few moments ago. What is really holding back the family from being able to move forward? And sometimes it is about dealing with those issues that traditionally I think courts have said, not for me to listen to your problems about how you broke up 14 years ago. But if that's still what those two people are talking about, that has to be managed somehow, not necessarily in the courtroom, but that's something that people should go away and talk about so they can get over the breakdown that happened 14 years ago and get to the present. I think the next slide. So we know that there are different programs available in different jurisdictions. I think both Matt and I have talked about a little of this in our earlier remarks. Some jurisdictions have mandatory mediation. In Ontario, we have mandatory intake. When I was a mediator providing court services, I was constantly surprised at how many people were sent to me sort of kicking and screaming, I'm here because the judge told me I can't have my matter called until. And we talked about the process, and we talked about what could happen and what they could expect to happen. And people would say to me, oh, I didn't understand. That's what this was about. So sometimes something as basic as mandatory intake can open a door for somebody to be thinking about things differently. I referenced a moment ago the mandatory court-based programs. Again, every jurisdiction has different versions of what this looks like. I hope that every jurisdiction with judges listening has some sort of information in this regard. I think it's important for us as judges to understand what's out there, look at that program, be able to talk about it and reinforce it and help inform the people by referencing what they have learned already by attending. We know that we can carve off and assign certain parts to professionals. I worry always about money. I'm appointed to a jurisdiction where there isn't a lot of services available because it's a small town. And what is available is not funded properly. And so there's the Cadillac version, there's the Chevy version, and then there's the reality with the wait list, the version that's just not accessible because of systemic problems. And so all of that has got to be part of what we know about our own local jurisdiction. So we're identifying services that really exist or who can move the file forward, not talking about something that's the ideal. Over to you, Matt.
Sure. A little bit more about early intervention. Obviously, what is it? An ounce of prevention is worth a pound of cure. These are cases, parent-child contact problems that get worse with time. Giving them time means if you're going to have any effectiveness, it's going to take more medicine. It's like a malignancy. So the courts have the ability early on to intervene, and with some subset of these cases, it's going to be effective. With some subset, it's not, and nothing that you do is going to be effective. But there are people who simply need some education, who are healthy enough, and they just are blowing it because they didn't realize how much damage they were doing to their kids. And that's where the mandatory court-based parent education programs, that's psychoeducation. And they are getting a lot better. These are online. Some of them are free, some of them cost minimally. These are things that you can order parents to do and give you a certificate. It only takes, 10 seconds of your time and signing the order. Very effective with a lot of people. And AFCC, again, to give them a plug, has really been on the forefront of evidence-based education, meaning they have been studied and they are effective with domestic violence, with alienation, and I can't stress enough how cost-effective early interventions can be, and judges can make them happen or create some kind of consequence when they're not, and that's a really potent intervention. Yeah. I want to talk a bit more about interventions. Just generally, we have 5 minutes, so I'm just going to hit the highlights. Most importantly, when you think about reconnection of a parent with a child or addressing rejection and resistance and refusal, it's not a dyadic relationship issue. It is a family systems issue. And the reason that that's important is because the preferred parent is going to say, not my problem. This is between Mary and her dad. Not true. At the very least, as you looked at that systemic diagram, you know that everyone in the system has something probably to do with the why this problem came about, and they're certainly going to have to be involved in any kind of resolution. You need buy-in. You need it either by insight, oh, I get it, I need to support this intervention, or by coercion. You support it. You get Johnny into that therapist's office, or when you come back and see me, I'm not going to be a happy judge. So it's also important, and I see this all the time, that orders that address parent-child contact problems don't just say therapist A will work with rejected parent and child to improve their relationship. That is absolutely structurally the kiss of death. It has to say all members, this is a systemic issue, so here are the essential components for interventions. First of all, there has to be a mandate that there needs to be work on the parent-child contact problem from the court. If you don't say, I have determined that there is value added for this parent to have meaningful contact with the child. If you can't say that from the bench, then whatever interventions that you determine need to happen by mandate will be a forum to argue whether the relationship should happen or not. So you have to go the step and have the information to be able to say, yes, this is mandated. This work on this relationship should happen. It is in the child's best interest to have this intervention to hopefully be effective in repairing whatever the problem is. If you don't have that mandate, it's a setup for failure. Secondly, obviously, the more understanding of the complexity of what's going on, the better. Thirdly, inclusion of all relevant individuals in the intervention. Sometimes the most important person in the intervention is grandma. She holds all the cards. She's got all the money. She's telling her daughter, "Look, I want this jerk out of the picture. Otherwise, you don't get to live with me anymore." If you're not aware of that and intervening with grandma, you're going to get nowhere. Just an example. Siblings, older siblings can be hugely important. So all relevant individuals need to be included and therefore mandated by the court when you put out an order that says this is a. If you have more than one person intervening, if you have more of that Cadillac model, make sure that they have the ability to work together. You can throw the 4 best, 3 best, 2 best mental health professionals in the county at a issue like this, and if they're not coordinating their work, they're going to replicate and reinforce the dynamics of the family. And finally, there has to be some linkage to the court, either delegated, like parenting coordination, or the judge has to stay involved, because if there isn't accountability, as Jerry was talking about, it's likely that you're going to have non-compliance. The progression of interventions, briefly, should flow from an it's kind of optimistic. The first thing you do is to say, I think they just have some dumb spots, so let's educate them. That can be done pretty cost effectively, as I said. Well, they came back and guess what? Not effective. Well, then they probably have some psychological issues. Loss, adjustment to loss, or trauma is involved, or some other kinds of psychological issues that if you can, are going to need to be addressed, because these are what we call blind spots. In other words, even though you give them the information, there are other blockages to their being able to use it. And then finally, when those things don't work, then you have to get heavy-handed and you have to switch the motivations of parents. If you have a parent who's engaging in a campaign of denigration and hate to damage and destroy the relationship with the other parent, you're going to have to make it cost them to do that more than to be able to do it. And that's where the authority, the coercive authority of the court becomes important. Some of these cases, no matter what you do, you get nowhere. And I want to talk a bit about them as a bit of a downer on our ending here. But it is reality that cases that don't respond to interventions typically have these kinds of characteristics: active violence toward a parent, severe untreated mental illness or personality disorder, fixed beliefs that are resistant to change, substance abuse, child abuse and neglect, and also vulnerabilities in the child that preclude their engagement in interventions because they're too stressful for them. And they can get self-destructive, or they can get incredibly dysfunctional. And that's a reality of the vulnerability of some kids in these highly stressful, high conflict situations. And kids come first over the rights of parents, even if their rights are being violated. So what happens when cases don't respond? Well, you're basically looking at a conundrum, which is that shared custody is not going to be a viable alternative in a case. You shouldn't come to that place unless you've exhausted available resources and interventions. But oftentimes, not oftentimes, but in rare circumstances, that does happen. And then you're in this conundrum as a judge of sort of weighing the harm to a child of staying exclusively in a residential situation that will result in impairment in social emotional development and functioning. That's with the favored parent. There are situations like that where you've determined that this parent is terrible, but the child is aligned with them versus the risks of changing custody to the other parent. Tough decisions for judges. Some considerations about changing custody. Well, you should work through and exhaust interventions. The favored parent's behavior sometimes rises to emotional abuse, and that should be a factor, obviously. And what tends to happen now is that in some situations, judges will order a temporary no contact with the favored parent and a change in custody. And if that's something that you're considering, there are protocols to do that. The risk to children is not great. Those kinds of supportive interventions to support the transition are pretty effective, actually. So that is a possibility if God forbid you get there in a particular case. And then obviously the other side of this decision that a judge needs to make, which is no longer in the best interest side of the continuum, it's in the least detriment side of the continuum, is saying that custody will stay with the favored parent and the rejected parent will not have contact. And I think, again, the considerations about the child in either situation are important, and then how you implement that decision, because what we know is that when alienation occurs severely and a parent's contact is no longer with the child at all during their minority, they actually do in young adulthood go back and seek out that parent. Yeah. Very commonly. And there are ways to set up the ending of interventions to try and get connection that will make that, when that occurs, the likelihood of that being healing more likely. So things like a ritual where that parent tells the child that they are no longer going to pursue custody, but they love them and the door is always open. Expectations that the favored parent has to continue to share information. I've had orders where the judge has ordered the favored parent, even though the child is not seeing the rejected parent, that they have to provide on a monthly basis pictures, a narrative letter, report cards. You can imagine that if they have to do that for a few years while that child reaches minority, when that child goes back and sees that parent, they're not strangers. That parent can say, "I saw the picture of your junior prom, and I know that you got great grades." So it's not don't just consider it to be a failure if that's where you go. There are ways to structure the letting go that can optimize what often happens when this child seeks out that parent. So I think that's our presentation, and we each wanted to make a couple of comments at the end and end it with that. So my comment is twofold. One is I'm incoming president of the Association of Family and Conciliation Courts parent organization. We have it's an interdisciplinary family court organization. Judges, attorneys, mental health professionals. It's public, it's private, and it really is the model, I think, for individual jurisdictions. I've spoken in the last month at 3 different counties in California. Each county has its own family court jurisdiction about this issue. And the most encouraging thing for me was that I went down there to speak as kind of the national expert, and there are 50 people in a relatively small county, and all 3 or 4 family court judges are there. That's the encouraging thing, because they're the leadership. And secondly, the private and public sector, mental health, and attorneys are all there. And that's what's got to happen if you're going to be effective in treating and intervening with these kind of cases. That's what I think that judicial officers, you don't realize potentially your presence at a training like that is so inspirational for everyone else who works in the jurisdiction in those counties. I know it is for me when I come and speak. If there's a judicial officer in the audience, I'm just like, this is so great, because I know how much power and authority you have. So thank you
Well,
for
thank you.
for
I'm
your
glad
time.
that I
I'll turn it over
intimidate you, Matt. I know
to
you didn't
our
really say that,
judicial officer
but
for
I think Matt
the
Sullivan intimidates me. So here's what I wanted to say, and it really goes back to the rejected parent. I think that, objectively, that's probably the place none of us ever want to be, because in so many ways, it's a failure of everything that we have just said to pull out of the toolbox, to try. Everything we know from research, social science, everything that I've just said about authority and judges. But I want to end with a story that a colleague of mine that I sit with had this scenario with a rejected parent. And all of the steps were tried, short visits, therapeutic interventions, voice of the child, an assessment, then a parenting assessment of dad and the children. And it was clear it was alienation. And, if we had 150 pages of documents, 150 pages said that. But at the end of the day, the children were teenagers by the time my colleague had to deal with it. And she talked the mother into letting go. And as part of that process, she had the mother write a letter to the children. And to make sure that the children got the letter, she had the children come into her courtroom, and she had the letter read to them by their own lawyer. Excuse me. And that was very powerful for her as a judge to feel that she was doing something. It was a lovely letter, along of what Matt says. When these children grow up and are in their 20s, or perhaps before then, they're going to knock on that mother's door, and they're going to have information along the lines of what Matt has said. So while it sounds like a very sad story, and one that demonstrates the failure of the judicial system to help this family, I think that my colleague found a way to think about the future for these children, give them this letter, give them this tool. The assessments and all the court documents will be available to them should they wish, and at some point in the future they can look at it. So when they knock on mom's door and say, yeah, well, you said you loved us, but you never showed up at this and that, there's going to be a challenge to that. And that, I think, and she thought, was part of helping the children heal into the future. And so I say it's about hope. It's about optimism. You don't know when you're going to make a difference. You don't know what you say today to a family will be very helpful to them at some point in the future. So we have to keep trying, and we have to keep trying with people from AFCC, because they have a wealth of information and knowledge, and that will only continue to grow when Matt Sullivan becomes president.